Well, good afternoon, everybody. It's 1 o'clock, so I think we'll probably get started, and people who join us as we move along can catch up. I'm Michelle Painter, one of the Silks online Selborne, and how wonderful to see so many familiar names. Hello, Elisa. Hello, Katrina. Hello, others. We've decided to revise these online CPDs, which we mostly conducted last year and the year before while we were all locked down during COVID. But they were a good way, we thought, for us to connect with our solicitors in the middle of a busy time. So I'm really glad that we can revamp the program. Our offering today is on administrative law, and we have three speakers with a wealth of experience and some really interesting different perspectives. We'll start first with Garry McGrath, Senior Counsel. Garry is one of the more experienced members of our chambers. He was admitted to the bar in 1984 and took silk in 2010, and he's recently joined this floor after a long career on, I think, on 8 Wentworth. Anyway, he's now ours, and can I welcome you, Garry, ask you to turn on your computer and talk to us about errors in fact and errors in law.
Can I firstly attempt to share my screen with you and see if you can see what I'm looking at? Can you see that?
Yes, we can.
Good, thank you. Well, I'll talk to that as best I can. Having chosen this topic, I have to say it was a great mistake, because all of the judicial comments I've read while preparing it indicate that it's an extraordinarily difficult thing to do. And I've put in the first, you'll see the first quote in this paper from Dr. Flick, as he then was, is one distinction that's long bedeviled administrative law is the distinction between an error of law and an error of fact. What makes it worse is that when you look at the statutes for review, either by a superior court or by an appeal tribunal, they sometimes state the right of appeal in terms of an appeal on a question of law, a right of appeal on a point of law, or a right of appeal on an error of law, and it's not subject of this paper, but it's clear they make a distinction between what you are able to do in each of those cases, and it is different. This paper concentrates on the distinction between an error of law and error of fact. Dr. Flick firstly says that that distinction is not without theoretical significance. The fact that he mentioned that it wasn't without theoretical significance indicates, as becomes apparent through the course of the paper, that in theory, in many of the judges' minds, there is no difference. And in many judges' minds, it seems to be the case that they can determine whatever they want it to be and recharacterise an error of fact as an error of law if they want to permit you to review the appeal. Now, for most of us, there are cases where it's easy to say that an error is an error of fact or an error of law. This paper only deals with that question or that distinction in the context of statutory reviews or judicial reviews of an administrative body or tribunal. But if you go to paragraph 3, you'll see from Dr. Flick's opinion in 1983, he says that the way is left open for a court, if it wishes to, to review the findings, that's the factual findings of an administrative tribunal, and a decision in fact reached by the tribunal, an error which can appear to be simply classified by the court, can simply be reclassified or classified by the court as an error of law, if the court does want to intervene, and if it doesn't, as an error of fact. He says that although making that wall statement might seem that like that it is arbitrary and the court can do what it wants whenever it wants to, he continues in his paper to say that the question should be carefully considered, and there are good reasons for the distinction. And I'll take you to his conclusion in due course, but his conclusion is that irrespective of whether the error of an administrative tribunal is one of fact or law, there should be a reluctance to review it. That's his view. But he does suggest, as I've said in point number 4, that the scope of judicial intervention to challenge factual findings is wider than many of the texts indicate. And now the general rule of which really delimits what are findings of fact is set out in paragraph 5. So in general, the court won't normally evaluate evidence presented to the tribunal or indeed a court below and reach a different conclusion of fact, weighing up the evidence for itself. The second part of that paragraph indicates what we're involved in considering here, namely that it is possible for a court to upset a finding of fact by deciding that in reaching the finding of fact, the tribunal committed an error of law. However, formulating or recharacterising an error of fact or recasting it attractively enough for the court to say, yes, it's an error of law, is not as easy as that bare statement sounds. Can I suggest to you that you do read Dr. Flick's paper, though it's somewhat old, it's a 1983 article. It is intensely thoughtful and researched. It unravels the mind as you read it, let alone when you seek to apply it to sufficiently try to characterise errors of fact as errors of law to interest a review tribunal or a superior court in intervening in your case. And as I mentioned later in this paper, it seems very unclear and still remains unclear as to when you can achieve that purpose. But this paper simply seeks to draw together from Dr. Flick's article and from other guidelines, other sources, some guidelines for when you're attempting to recast or cast an error of fact as an error of law. It's not an exhaustive list. In fact, there aren't many cases when it can be done, but it is possible in certain instances. As a starting point, Dr. Flick refers to an American decision, and I've set that out in paragraph 9. He does that to really make the first distinction he wishes to make, that is between primary facts and ultimate facts. I'll go and read just the 4 stages that he says an administrative decision-making body is involved. There are A, B, C and D in that paragraph. Firstly, it takes the evidence, weighs it as to its accuracy and credibility, and then basic and underlying facts are found, and the findings made in that way are the primary facts. And then the ultimate facts, usually in the language of the statute, are either found from the primary facts or inferred from the primary facts. And then finally, the reviewing body, the administrative body, applies the statutory criteria to the facts. Dr. Flick says findings of ultimate facts are required to ground the application of the statute. And the findings of ultimate fact, however, are often reached on conclusions from the primary facts. Now, I know this is a very boring topic. It's certainly no easier when you read the article. And as I'll mention when we come towards the end of the presentation, the confusion that Dr. Flick highlighted in 1983 still exists today, and I'll go to a 2015 full bench decision of the Federal Court, which I'll refer you to, but won't set out in any detail. I'll just mention the paragraphs which confirms most of these or many of these points, and I encourage you to read it as well. The first way in which errors of fact might be used to ground a review of an administrative decision is where there are errors of law concerning the inferences made by the tribunal from the primary fact. The drawing of inferences from primary facts involves a process of drawing of inferences in many cases, and the drawing of inferences permits an opportunity for the application of wrong legal principles. As Dr. Flick says, even that is a question of degree, and you've got to be very careful. But I'll come back to that. But the drawing of inferences from primary facts is one of the most important focuses when seeking to challenge a factual decision on a review, either by a review tribunal or by a superior court. In paragraph 13, I mentioned one other means whereby it may be possible to challenge primary facts. And again, this involves, as do all of these questions, very close attention to the statutory provisions that apply to the tribunal and apply to the tribunal's decision-making process, and also to its the way in which it gives its decision. Some statutes require the administrative tribunal not only to set out the grounds of its decision, but also require it to set out certain substantive facts, so that if there is an absence of reasons for given by the tribunal, and they have omitted the mention of a particular fact, that is a ground in addition to the drawing of inferences, which can be used to challenge facts below. One thing I mentioned, I'm trying to summarise this, tribunals can often be sought to be challenged on the basis that there's no sufficient evidence for a finding of fact. The best view on that presently seems to me to be, from my reading, that it's uncertain as to whether that's an error of law. There are cases both way on that issue, and I've dealt with it in the paper. I don't know whether I can make this paper available, might save some time dealing with it at any great length because time is short. There is another distinction that Dr. Flick requires or suggests we consider, and that is jurisdictional facts. They're really a subset of ultimate facts, and they're facts that must be found in order to ground the jurisdiction. A challenge may be made to those if, for example, the tribunal excludes evidence wrongly, which does not let it form a finding or a holding that it has got jurisdiction to hear a case. So it may, you may be able to use the exclusion of evidence and the failure to make a factual finding on that basis as a way of challenging a tribunal's decision by using the facts rather than using an error of law. It may, as I say in 22, it's the tribunal may have denied itself of jurisdiction by failing to make a particular supporting fact. There are some other inferences that are important to bear in mind. Inferences that require the skill of a lawyer to make from a finding of fact obviously are open to challenge, because if law is necessary and there's an error in the legal in making an inference that requires the skills of a lawyer, that is another basis on which there can be a challenge of the findings of facts made by an administrative body. If I can go to 31, can I see there? There's a quote I will from His Honour Justice Gibbs, as he then was, and I'll just read that out to highlight again the confusion in this area. The court, he says, is called upon to consider whether the alleged error is one of law or fact, an inquiry of a sterile and technical kind, but frequently productive of agreement. But Dr. Flick's conclusion I set out in paragraph 32, and I'll make this paper available. As I've said before, his suggestion is that irrespective of whether there's a finding an error of fact or an error of law, the tribunals should be, the reviewing tribunals or court should be reluctant to interfere with the decision of administrative bodies. That's a salutary warning not to be too creative in recasting errors of fact as errors of law. Just to bring you up to date, you'll see in paragraph 33, I mentioned the decision of Harathos, and I mentioned the most relevant paragraphs of it. That concerns the question of mixed questions of fact or law, and you will see that there is no, if you read those paragraphs, which I commend to you, you will see that the same reluctance is there for the court to find that these distinctions are easy to make, or in fact that these distinctions serve any real purpose. That case again highlights the necessity to carefully consider the statutory provisions under consideration. It may be, as it was in that case, that the statutory provisions did allow an appeal from a mixed question of fact or law. Whether there is such a thing as a mixed question of fact or law is not clear. It becomes apparent reading that decision that one must first discern the errors of fact and then the errors of law. It becomes a far more attractive proposition to the court if you can describe your factual challenge as an error of law and make it appear to be an error of law in fine detail. I include in paragraph 35, and this is the last thing I'll mention, another critique by the court to show how difficult it is to determine these things. And it's from paragraph 166 of Heritos, and I'll finish up with this. More recently, mixed questions of fact and law have been described as one of the baffling gadgets in a judicial toolbox. And in fact, as the quote continues, Sir John Laws has said extrajudicially that there's no such thing as a mixed question of law and fact. I say that for this reason. In conclusion, it's important that you cast your challenge to fact very clearly as an error of law. And I have to finish up due to the time constraints we have here, but if the paper is of any assistance, I will make it available. And thank you for putting up with that somewhat dry and boring and perhaps very truncated dissertation. Thank you.
Thank you, Garry. Could you stop sharing your screen now, please?
Yes.
Thank you very much. And any of those watching or who find out about this later who'd like a copy of Garry's paper should contact our clerk, Ella Baxendale. If you don't already have her details, they're available on the website and we'll make a copy available. Thanks, Garry. Let me move on to our second speaker, Nicole Maddocks. I think I started to tell you that Nicole had come to join us last year in the middle of a COVID lockdown. One of the bravest readers I've ever met, I think. Before she came to the bar, Nicole practiced as a solicitor for 7 years at Spark Helmore and DLA Piper. She's going to talk to us about the re-exercise of power, and in particular with reference to section 33 subsection 1 of the Acts Interpretation Act and a couple of illuminating cases. Over to you, Nicole.
Thanks, Michelle. I'll just check everyone can hear me before I get going. Fantastic. And second thing, I will attempt to share my screen, which hopefully, someone give me a thumbs up if you can see that. Fantastic. Thank you, Garry. Okay, so as Michelle said, my presentation today is on two recent decisions of the High Court and the full Federal Court, which have considered the circumstances in which section 33 subsection 1 of the Acts Interpretation Act will allow a decision maker to re-exercise a decision-making power where there has been some change of facts since the first decision was made. Now, the two decisions arise in the migration law context, and you might think, I don't practice in migration law, this has no relevance to me. However, these decisions are a timely reminder of what needs to be considered when a statutory power is sought to be re-exercised. So turning first to the relevant provisions of the Acts Interpretation Act, Section 2 provides that the Act applies to all acts, and then there's a carve out in subsection 2 that is subject to any contrary intention. You've then got subsection 33 1, which provides that where an act confers a power or function or imposes a duty, that power may be exercised from time to time as occasion requires. Now, the first decision I'm going to talk about is a decision of the High Court in Makasa, which was handed down in February last year. And the relevant decision-making power in that case was Section 500, subsection 1 of the Migration Act, which should be on the screen there for you. It gives the minister a discretion to cancel a visa if the minister reasonably suspects that the person does not pass the character test and the person does not satisfy the minister that the person passes the character test. So if A and B are met, that's the first stage of the two-stage decision-making process. And then the second stage is the exercise of discretion as to whether or not to cancel. I've also just got on the slide there the definition of, or part of, definition of character test and substantial criminal record for context. Now, the facts of Makasa were as follows. Mr. Makasa was granted a permanent residence visa in 2004. In 2009, he was convicted of 3 offences related to sexual intercourse with a person aged between 14 and 16 years of age, and he was sentenced to 3 concurrent terms of imprisonment, each of 2 years. So just pausing there, he had a substantial criminal record for the purposes of Section 501. In 2011, a delegate of the minister cancelled Mr. Makasa's visa under Section 501, subsection 2, having suspected that he failed to pass the character test as a result of those 3 convictions. He then applied to the Administrative Appeals Tribunal for review of that decision, and on review, the tribunal set aside that cancellation decision. Some time then goes on, and in 2017, Mr. Makasa was convicted of 2 further offences. One was failing to comply with a reporting obligation, for which he was fined $300, and the other was for driving under the influence of alcohol, for which he was disqualified from driving for 12 months and fined $1,200. In 2017, the minister personally purported to exercise the power conferred under Section 501, subsection 2 of the Act to cancel Mr. Makasa's visa. The minister was satisfied that he failed to pass the character test solely by reason of the 3 sentences relating to the 2009 convictions for sexual assault, but took into account the 2017 convictions in the exercise of discretion. Mr. Makasa sought judicial review of the minister's 2017 decision in a federal court. At first instance, Justice Burley dismissed the application. Mr. Makasa then appealed to the full federal court, who by majority allowed the appeal and quashed the minister's decision. The minister then sought and was granted special leave to appeal to the High Court. Now, the issue before the High Court was whether the minister could re-exercise the discretion to cancel Mr. Makasa's visa on the same factual basis as the first cancellation decision. In other words, whether the same failure to satisfy the character test in the presence of changed circumstances relevant to the exercise of discretion was sufficient, or there needed to be new facts going to the first stage of the decision-making power. In determining this issue, the High Court had regard to the application of Section 33, subsection 1 of the Acts Interpretation Act. And the High Court found that there was an intention contrary to the application of Section 33, subsection 1, both in the Migration Act and the AAT Act, that meant that the power conferred by Section 501, subsection 2 could not be re-exercised in the absence of subsequent events or further information. So the High Court found that this intention emerged by reference to 2 principal considerations. The first, which the High Court described as narrower in its ambit, arises from the operation of the AAT Act, and that's what this first quote of paragraph 50 is going to here, the court noted that the AAT's function of standing in the shoes of the decision maker would be reduced to a mockery were the subject matter of the decision made by the AAT on review able to be revisited by the primary decision maker in the unqualified re-exercise of the same statutory power already re-exercised by the AAT in its review. The second consideration which the High Court had regard to was the relationship between Section 501 subsection 2 and Section 501A of the Migration Act, the latter of which provides the minister with a ministerial override power which can be exercised without the need for any change to the factual circumstances. And the court found that Section 501A must be read as manifesting a legislative intention to exclude re-exercise by the minister under Section 501, subsection 2 of the Act, where there had been no change to the factual basis on which the previous decision maker had formed that reasonable suspicion that the visa holder didn't pass the character test. So the High Court unanimously held that Section 33(1) of the Act's Interpretation Act cannot mean that the decision maker can simply re-exercise the discretionary component of that decision-making power, or the second stage of that two-stage decision-making process. Rather, there needed to be some factual basis or change to that first stage of the decision-making process. The second decision that I'd like to take you to is a judgment that was delivered by the full federal court in February this year. I appeared in this matter for the appellant led by Tom Bagley on my floor. The decision-making power in this matter was somewhat more complicated in the legislative scheme compared to Makasa. The decision-making power was Section 501, subsection 3A, which imposes a duty on the minister to cancel a visa if the matters in paragraphs A and B are satisfied. So in other words, if the minister is satisfied that a person does not pass the character test for one of four reasons, and the person is serving a sentence of imprisonment, there is a duty on the minister to cancel that person's visa. Now, when a visa is cancelled under that section, there is a process under Section 501CA of the Migration Act by which the applicant can make representations to the minister that the cancellation decision should be revoked, in which case the minister then makes a further decision, which is either a revocation decision or a non-revocation decision. The scheme also provides that the cancellation decision under Section 501 subsection 3A is not reviewable by the tribunal. Instead, it is the non-revocation decision that is reviewable. Now, the facts in XJLR were as follows. The appellant was born in New Zealand and he moved to Australia in 1992 at the age of 17. In April 2011, he was granted the relevant visa. In November 2014, he was convicted of possessing unlicensed firearms, which led to a 45-month sentence of imprisonment, which was imposed in June 2015. In July 2016, while he was serving his sentence of imprisonment, a delegate of the minister cancelled the appellant's visa pursuant to Section 501, subsection 3A of the Migration Act. In September 2016, another delegate of the minister decided to revoke that cancellation decision. Moving on to 2018, the appellant was then convicted of various offences, none of which either on their own or cumulatively met the definition of a substantial criminal record, and he was sentenced to a term of imprisonment. In June 2018, XJLR's visa was cancelled by a delegate of the minister under Section 501, subsection 3A. Now, the delegate relied upon the 2015 sentence to form the state of satisfaction that he held a substantial criminal record for the purposes of paragraph A. And then another delegate declined to revoke the decision. So XJLR sought review in the tribunal. Now, the issue that was before the full federal court for present purposes was whether the duty to cancel a visa under section 501 subsection 3A can be re-exercised after a previous cancellation based on the same failure to pass the character test under that paragraph A had been revoked. Again, the court had to give consideration to section 33 subsection 1 of the Acts Interpretation Act in determining whether the duty to cancel could be re-exercised. Applying Makasa, the full federal court found that the Migration Act does evince a contrary intention within the meaning of section 2 of the Acts Interpretation Act to prevent section 33 subsection 1 applying to the power in section 501 subsection 3A merely because of a new imprisonment of a visa holder. So the court again looked at the fact that there was this ministerial override power which existed, and that in part evinced the contrary intention. The full federal court accordingly found that the decision-making power could not be exercised more than once in respect of the same failure to pass the character test in paragraph A. In other words, it was impermissible for a decision maker to take into account and rely upon certain matters which had been relied upon by the decision maker in a previous cancellation decision. Accordingly, for the power in section 501 subsection 3A to be re-exercised, there must be a change of circumstances going to paragraph A or a new failure to pass the character test. The outcome of this decision meant that the applicant still held a visa and he was released from immigration detention. Now, the Minister has sought special leave to appeal against this decision, and we're currently waiting to receive a listing date for oral argument later this year. However, if special leave is granted, the High Court's decision is likely to provide further guidance on the circumstances in which section 33 subsection 1 of the Acts Interpretation Act will allow a decision maker to re-exercise a decision-making power. So turning to the broader implications of these decisions, they emphasise the need to consider the statutory scheme within which a decision-making power exists before re-exercising that power, and in particular considering whether the statutory scheme evinces an intention contrary to section 33 subsection 1 of the Acts Interpretation Act, which would otherwise allow that decision-making power to be re-exercised. So the important considerations are what are the constraints in the underlying statute and whether there is a new factual basis to re-exercise that decision-making power. Now, I'm not sure if anyone has any questions arising from that, but I'm happy to take them if you do.
Thanks very much, Nicole. I think we'll probably open up for questions at the conclusion of the next speech, but given that you've been unwell, I'm glad that your voice held out. Let me introduce our next speaker. Phillip is the most junior member of our chambers. He was called to the bar earlier this year, and before he came to the bar, he had been a solicitor for 8 years, and he worked during that time at 2 national insurance firms as well as a boutique firm in Canberra. He's got direct experience in the topics that we're discussing today. He will speak to us about materiality and the interpretation of executive power. Thanks, Phillip.
Thanks, Michelle. I'll just quickly share my screen and then get underway. Can everyone see that?
Yes, we can, Phillip.
Excellent. On the 15th of August 2018, the High Court published its reasons in Hussain and Minister for Immigration and Border Protection. In that case, the appellant's application for a partner visa was refused by both the Minister at first instance and then the Administrative Appeals Tribunal following merits review. To be granted a partner visa, the appellant needed to satisfy 2 criteria. First, that he had lodged his application within 28 days of his previous visa expiring, and second, that he had no outstanding debts to the Commonwealth unless arrangements for repayment had been made. The AAT found that the appellant had not satisfied either criterion. The appellant then applied to the Federal Circuit Court for judicial review of the AAT's decision. Before the Federal Circuit Court, it was common ground that the tribunal had made an error of law by applying the second criteria based on the circumstances at the time the application was made, as opposed to the circumstances at the time the tribunal made its decision. As a result, it was held that the AAT committed a jurisdictional error, even though the first criteria provided an independent ground to reject the application. The majority of the full court of the Federal Court overturned this conclusion on appeal. The appellant then applied to the High Court. In its reasons for judgment, the High Court agreed with the conclusion of the full court. However, it did so for slightly different reasons. The plurality of Chief Justice Kiefel and Justices Gageler and Keane focused on the concept of jurisdictional error and made two salient points. The first was that the concept of jurisdictional error, which is fundamental to judicial review in Australia, was not just concerned with the existence of an error by a decision maker. It is also concerned with the gravity of any error. The second was that to determine whether a particular error was one that took the decision maker outside of the jurisdiction conferred by statute, it was necessary to consider the proper construction of the statute. It followed from this that a statute conferring power on a decision maker was ordinarily to be construed as incorporating a threshold of materiality before departure from it would lead to invalidity. In other words, an error committed by a decision maker would usually not be jurisdictional in nature if it could not have made a difference to the decision in question. Materiality was subsequently explained in the High Court's decision of Minister for Immigration and Border Protection and SZMTA to involve a realistic possibility that the decision in fact made could have been different had the breach of the relevant condition or conditions not occurred. SZMTA was a decision in 3 appeals concerning the visa applicants BEG 15, SZMTA, and CQZ15. In each case, the Secretary of the Department of Immigration and Border Protection had provided statutory notifications to the AAT which had sought to prevent disclosure of certain documents or information to the visa applicants. In each case, the AAT had not disclosed the existence of the notification to the applicants, and each claimed a denial of procedural fairness on that basis. In all cases, a majority of the High Court affirmed the threshold of materiality developed in Hussain. Importantly, the majority also went further than Hussain in holding that materiality is a question of fact in respect of which an applicant bears the onus of proof. The majority held that any breach of the obligation to accord procedural fairness in SZMTA and BEG 15's proceedings was not jurisdictional because it could have made no difference to the outcome of those cases. The majority also agreed with the full court of the Federal Court that, in relation to CQZ15, the documents should have been admitted as they were potentially relevant to the materiality of the denial of procedural fairness in that case, however, still dismissed the appeal. A statement made by the plurality in Hussain, which was that decision-making is a function of the real world, directs attention to the question of whether Their Honour's development of the presumption of materiality was informed by pragmatism. The plurality statement was quoted from the judgment of Justice Hill in Eichmann, a 1992 decision of the full court of the Federal Court. The legislative provision in issue in that case relevantly empowered the minister to impose certain duties upon goods if satisfied that the export price of those goods was less than their normal value, resulting in threatened or actual material injury to an Australian industry. Duty was imposed on the appellant's goods on that basis. The appellant's complaint was that the respondent authority failed to consider a relevant consideration, being that the first appellant had in Italy a natural monopoly, which enabled it to achieve in that country a higher return than would otherwise have been available as normal value by reference to Italian domestic sale prices. In dispatching this submission, Justice Hill considered that it was not enough for the appellant to merely assert to the respondent that there existed as such a monopoly, without making out a case that the existence of the monopoly had some effect on the relevant market. It did not do so. It was not, therefore, incumbent upon the respondent to make further inquiries to ascertain whether the appellant's assertion was correct. In coming to that conclusion, Justice Hill said, "Decision-making is a function of the real world. A decision-maker is not bound to investigate each avenue that may be suggested to him by an interested party. Ultimately, a decision-maker must do the best on the material available after giving interested parties the right to be heard on the question at issue." In applying that proposition, His Honour went on to hold that, in circumstances where the respondent authority had afforded the appellants a fair hearing, the respondent had no further duty to inquire, and it therefore had not failed to take into account a relevant consideration. It is true that Justice Hill's reasoning in Eichmann provided for a pragmatic resolution of that case. However, in coming to that resolution, Justice Hill's use of the terminology of the real world was no more than His Honour adopting an expression apt to focus attention upon the well-established limitations upon the principle of a duty to inquire. As His Honour noted, by reference to the decision of Prasad and Minister for Immigration and Ethnic Affairs, such a duty is strictly limited. It is understandable that the court in Hussain sought support from the statement in Eichmann in the context of the operation of common law principles, which inform the construction of statutes conferring decision-making authority. But to seek refuge in the notion of the real world speaks of the operation of such principles. It says little, and nor does Eichmann, of why and how that notion justifies the creation of a threshold of materiality in the ascertainment of jurisdictional error. Even if it may be accepted that the concern of pragmatism contributed to the introduction of the presumption, the court gave little guidance as to why it did so. Nevertheless, as Lisa Crawford of UNSW has noted in a number of recent articles, it is possible to draw comparisons between Hussain and decisions of the English courts that have more expressly delivered judgments infused with the spirit of pragmatism. A telling example of that approach can be found in the Queen and the Upper Tribunal. In that case, Baroness Hale stated that a certain level of error is acceptable in a legal system which has so many demands upon its limited resources. As Crawford has noted, perhaps the court in Hussain was animated by that broad issue as to how courts should seek to balance the competing demands of legality with the practical realities of the administrative state. But is that what animated the court in Hussain? We do not know because it did not tell us. However, what we do know from Nettle and Gordon's judgment in SZMTA, and more recently from each of their honours' separate reasons in ABT 17 and Minister for Immigration and Border Protection, is that the threshold of materiality has sidelined what may be said to be a competing pragmatic concern. To take one ground of review as an example, as Justice Gordon noted in ABT 17, the principle of procedural fairness, as now overlaid with the materiality threshold, has been changed. It now requires a decision maker to accord procedural fairness if and only if to do so would make a difference to the ultimate decision. The guarantee of procedural fairness is removed. More broadly, in SZMTA, Justices Nettle and Gordon observed, Parliament cannot be taken to intend that a decision maker need only comply with laws to the extent that a failure to comply would not bring about a different result. Any such conception would be contrary to the notion, central to the conceptual foundations of judicial review, that everyone, including a decision maker, is bound by the law. Their Honour's observation is entirely consistent with what Justices Gordon and Gummo stated in Ex parte Ala was the animating principle set out by Justice Gordon in Ironfield City Corporation, where Her Honour had said, within the limits of their jurisdiction and consistent with their obligation to act judicially, the court should provide whatever remedies are available and appropriate to ensure that those possessed of executive and administrative powers exercise them only in accordance with the laws which govern their exercise. The rule of law requires no less. Thus, it cannot be said that Nettle and Gordon were impliedly asserting that the new presumption's classification of an error as non-jurisdictional, if it does not meet some threshold of materiality, is wrong in principle for the reason that the classification of any error as non-jurisdictional is contrary to the rule of law and fundamental judicial review principles. Their Honours did not suggest that the distinction between jurisdictional and non-jurisdictional errors should be abandoned. Their Honours were instead concerned with the creation by the new presumption of materiality of a new species of non-jurisdictional error, a species which they felt was, and with respect is, contrary to well-established fundamental principle. Be all that as it may, Justice Nettle and Gordon's passage provides a strong basis for the conclusion that it is decidedly unpragmatic to create a diminished obligation upon decision makers to comply with the limits of their powers only to the extent any error they make is material. As Annalise has observed, such a principle arguably opens the door for non-compliance, when compliance both improves administrative efficiency and promotes the public interest. Further, although their Honours did not couch their concern in this way, such a diminished obligation may create more confusion for decision makers as to the precise bounds of their power. Justices Nettle and Gordon in SZMTA and Justice Gordon more recently in ABT 17, with whom Justice Nettle agreed, make a compelling case against the main development in SZMTA. That development was the plurality's assertion that where materiality is put in issue, it is a question of fact in respect of which the applicant for judicial review bears the onus of proof. In SZMTA, Justices Nettle and Gordon expressed two concerns with that shift in the onus of proof, a shift that their Honours felt was reason enough to reject the threshold of materiality. First, their Honours noted it would challenge the fundamental principle that a statutory power is to be exercised under and according to the terms of the statute. For their Honours, the presumption would require identification of materiality by an applicant after the decision was made, as opposed to under the statute. This was an important factor for their Honours because a finding of jurisdictional error means that the decision is a nullity or no decision at all. It is for this reason that their Honours emphasised, similarly to what Justice McHugh observed in SAAP, that a decision cannot be a little bit invalid or a little bit beyond power. And that being so, if a decision is found to be invalid, it is then for the decision maker to seek for the court to exercise its residual discretion to refuse relief. And in so doing, it must establish the futility of any such relief. As Justice Nettle and Gordon noted, the playing field is set by the statute, not the decision maker or the court on review. In ABT 17, Justice Gordon expanded upon this proposition, noting that the statute's playing field is known in advance, and thus the statute ensures that decision makers know what is required of them when carrying out their tasks. Further, Her Honour observed that the determination of any error is to be ascertained at the time of a decision maker's exercise of power. Her Honour observed that these two principles have an important consequence, being that judicial power does not permit a court to inquire in hindsight whether an error was material, thereby modifying the statute. Secondly, their Honours in SZMTA and in ABT 17 caution that the onus shift would create the risk that judicial review will become a forum of merits review. The threshold of materiality will see applicants putting on evidence going to that issue, seeking to show how they may have conducted themselves should the error not have occurred. This has implications for a slide into merits because in such circumstances, a court may need to consider how that evidence may affect the merits of the case to determine what a particular outcome would have been but for the error. Although the determination of counterfactuals is a commonplace judicial technique in many areas of the law, such a determination in the context of administrative law is of acute concern. The High Court has consistently warned of the danger of the elision of judicial review with merits review. As Justice Brennan famously stated in Quinn, the merits of administrative action, to the extent that they can be distinguished from legality, are for the repository of the relevant power and subject to political control for the repository alone. These compelling reasons to reject, at the very least, the shift in onus of proof now established, these are compelling reasons to reject, at the very least, the shift in onus of proof now established by the threshold of materiality. For completeness, it should be noted that in MZAPC and Minister for Immigration and Border Protection, a recent decision in which the appellant sought to challenge the shift in the onus of proof wrought by SZMTA, the High Court said, where materiality of a breach of an express or implied condition of a conferral of statutory decision-making authority is an issue in an application for judicial review of a decision on the ground of jurisdictional error, the onus of proving by admissible evidence on the balance of probabilities historical facts necessary to satisfy the court that the decision could realistically have been different had the breach not occurred lies unwaveringly on the plaintiff. Much of the prior authority relied upon by the plurality in Hussain and SZMTA was authority for the proposition that an error which did not deprive the party of a successful outcome may justify the refusal of relief by the exercise of the court's residual discretion. Justices Nettle and Gordon in SZMTA, and both writing separately in ABT 17, emphatically endorsed the approach that the exercise of the residual discretion to refuse relief should be the course adopted for errors of the kind in contemplation in such cases. Their Honours noted in SZMTA that a different and separate inquiry, which should not be confused with the identification of jurisdictional error, is whether to exercise the residual discretion to refuse relief after jurisdictional error has been established, if no useful result could ensue. Conceptually, this would be the most principled approach to the determination of the consequences that should flow from a non-material breach. This is plain for the reasons given by Justices Nettle and Gordon, as just discussed, in respect of the onus of proof, and for the reason that no persuasive justification has been advanced by the court for the presumption of the threshold of materiality, either on the basis of prior authority or on the basis of the court's power to evolve its interpretive presumptions. In this brief talk, I have sought to demonstrate that the presumption of the threshold of materiality is not grounded in a legitimate justification, is not supported by prior authority, and in practice has unintended consequences. It also raises many further questions. These include, what is the significance of the statements in certain English authorities referred to by Justice Edelman in Hussain and by Justices Nettle and Gordon in SZMTA that have incorporated a notion of materiality, especially in circumstances where, as all those judges have recognised, the distinction between jurisdictional and non-jurisdictional error in that jurisdiction has been reduced to a vanishing point. Further, as Justice Mortimer has asserted, are procedural fairness and unreasonableness review not encompassed within the bounds of the presumption? Or will an application of those grounds see the presumption rebutted? Or at least will an extreme case of denial of procedural fairness, as adverted to by Justice Edelman in Hussain, be sufficient to displace it? Finally, much has been said about the potential for the statutory approach to swallow up the grounds of review, an issue arguably made starker after Minister for Immigration and Lee. Is materiality another step in that direction? These are all large questions, the answers to which will no doubt play out in future cases and in the fullness of time. Thanks very much for listening.
Thank you very much, Phillip. We are running very short of time, but I'm sure we do have time for a question if anyone has some burning issues they want to raise. I was thinking, though, wondering, and Phillip, feel free to jump in, or any of our other speakers, if the question of jurisdictional or non-jurisdictional error, how that fits in with the error of fact or error of law dichotomy. But I do think that may be need to be the subject of perhaps a further seminar, certainly another day. Anyway, can I open the screen or the floor virtually to anyone who has a question? Wave your hand or put your camera on or something. Yes, Garry.
Can I just mention this? I'm assuming that the materiality issue is not relevant where there's an error of law on the face of the record, and that in that circumstance you don't need to deal with the question of materiality. Is that right?
Yes, I think that's right, Gary.
Thank you.
Terrific. One last chance for anyone else. Otherwise, I will ask you all to join me in thanking our speakers and ask you to contact our clerk if you'd like a copy of any of the presentation materials, to contact me or our clerk if you want to suggest a topic for any future lunchtime CPD, and to ask you all to stay tuned because I'm sure there will be some more. Thanks, everyone.
Thank you.
Thank you.
You.